Society, platform for eminent authors, engaging teachers, successful students. To know more, email. Characteristics of consideration. Following are the characteristics of valid consideration. Need not be adequate. Normally, the consideration which is the mutual benefit to accrue to the parties to the contract should be adequate to induce both the parties to come into contract. However, from legal point of view, consideration must be of some value but need not be adequate. The law requires that there must be consideration in every contract. The contract is valid even on inadequate consideration provided the consent of the parties is freely given, that is, given with free consent. Example, A promised to sell his entire lot of antique furniture at rupees 10,000 only, which B accepted. Held, this is a valid contract even if the consideration is inadequate. The consideration need not have any regard to the actual value of the furniture. Must be real. Consideration must be real and not illusory. A contract to do something illusory, unreal and impossible is not valid. A promises B to bring life to his dead wife from the bed. This is not a valid consideration as it is unreal and impossible. Not be duty of the promisor. Consideration must not be something which is the duty of the promisor. No consideration emerges for something done which the person is bound to do under the law or a part of duty. A's son is missing. He registers a police diary. Meanwhile, he also declares a reward whoever can fetch his son. A policeman of that police station brings back his son and asks for the reward. Held, the policeman cannot claim the reward because it is the duty to fetch his missing son, for which he has already reported to the police station. Lawful. Consideration must be lawful. It must not be prohibited by law, illegal, immoral or opposed to public policy, involve injury to any person or property. Example, A promises B to pay rupees 1 lakh to abduct C. This is not valid consideration as the object is illegal. Abstinence or forbearance. Abstinence or forbearance may be a consideration. Sometimes the consideration may be abstaining from doing some act, that is, not to do something act. Non-doing of certain act by a party results in negative consideration. A's veranda on first floor fell down and injured B in the ground floor. B threatened to sue A unless A promised to pay rupees 500. A promised to pay B for B's abstinence from suing, that is, if B does not sue. B did not sue and claimed the money from A, but A refused to pay, claiming that there was no consideration for his promise. B can recover the amount from A because B's abstinence from legal suit is a valid consideration. May move from promisee. Consideration should move from promisor to promisee, but it may also move from promisee or any other person. Where a third party furnishes the consideration, it is valid consideration, sometimes referred as doctrine of constructive consideration. This is also stated as privy of consideration is not required. Example, A and B, two brothers on partition of joint family property, agree between themselves to invest some money to support their mother. the mother may now enforce A and B to make the investment, as she was the beneficiary of the consideration to the contract, though she was not a direct party to the agreement. Example: a lady A had an old sister C whom she loved. A transferred her property to her daughter R to regularly pay C. C made an agreement with A promising her to pay C regularly. Later on, R refused to pay C on the plea that there was no consideration moving from C to R. Held, R was liable to pay C as the consideration has moved from C. So consideration may move from third party also. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.